Hello students, I am Dr. Jyoti Shetty. Today I am going to deal with the new legislation, that is the Prevention of Corruption Act 1988. For the sake of writing descriptive answer for the based on this legislation, you have to prepare for the historical background at first. For example, this act was enacted at first in 1947, then there was amendments and there was the amendment in 1964. Now we have the Prevention of Corruption Act which are enacted in 1988. It has 5 chapters and 31 sections. It is very small legislation but very effective one. And apart from that, then you have to focus on the objectives of this legislation. The first and most important objective of this legislation is to establish the special courts for the speedy trials. Then to prevent the misconduct in the official government offices. And suppose anybody found to do such kind of the misconduct, then there are the provisions included for the sake of prosecution as well as punishment for the same. Even this legislation create a vigilance commission to investigate the corruption cases. Apart from this, one of the objective which is very important one is to promote awareness and education to discourage the corrupt practices. So this is the objectives of the Prevention of Corruption Act. Now let's see what are the contents relating to the chapters. We are going to deal one by one. Let's see. Today, we are going to deal with the Prevention of Corruption Act 1988, which is also called as Anti-Corruption Act. It contains 5 chapters and 31 sections. I made a scheme of the whole act, which is a very useful for student for understanding. Chapter first, which includes the preliminary provisions, section 1 to 2. Then chapter second includes appointment of the special judges, section 3 to 6. Chapter 3 deals with the offences and penalties under the Prevention of Corruption Act 1988 under section 7 to 16, which is very important part from the point of view of your examination. Then chapter 4 includes the investigation into the cases under the Act, section 17 to 18. Then chapter 4A also inserted in 2018, which deals with the attachment and forfeiture of property, section 18A. Then chapter 5, which is the last chapter, which deals with the sanction for the prosecution and other miscellaneous provisions under section 19 to 31. So this is the scheme of the whole act. Now one by one we are going to deal with each chapter. The first important chapter, that is the definition, we are going to deal with the same. Now let's see definition part. Under the definitions, under section 2, a very important definition, that is the public duty from the point of view of examination also. The Prevention of Corruption Act 1988 defines section 2 subsection B, public duty. What is the definition? A duty in the discharge of which the state, the public or the community at large has an interest. Here, this definition having the explanation for the word the state. The state includes the corporation established or by or under central, provincial or state act, or an authority or the body owned or controlled or aided by the government or government company. So this is the way of remembering the definition as it is, and it is a very easy one to remember the pointers. After that, but in examination you have to write down in the sentence format. Okay, so let's see the next definition. Now, let's see the second important definition under the Prevention of Corruption Act 1988. Section 2, subsection C defines public servant, that is, any person in the service or pay of the government or remunerated by the government fees or commission for the performance of any public duty. This definition given a certain categories who are coming under the purview of the public servant, and before writing the definition of the public servant you have to write down the definition of the public duty. So the next part that includes any person in the service or pay of local authority, corporation. Here corporation includes central, provincial or state acts, even judges, arbitrators, even the persons who are included are or who are doing election duties coming under the purview of the public servant. Even the president, secretary, or the office bearer of registered cooperative society who are working for the industries, trade, banking, etc. Even vice chancellor or the governing body of the universities also coming under the definition of the public servant. Even employees of the educational institutions who are getting the financial assistance from the central or the state government, they are also coming under the purview of the public servant. So this is the very important definition. Now let's see the next one. Now, let's see next important definition. Section 2, subsection D defines undue advantage. It means any gratification whatever other than legal remuneration. This definition also give an explanation. The explanation is very important one. That is, the first one, this definition is not limited to the pecuniary gratification only. And second one, the definition of undue advantage does not include legal remuneration. Now, this definition also given the explanation what is the meaning of legal remuneration. Actually, legal remuneration includes all remuneration which he is, means the public servant, is permitted by the government or the organization which he serves to receive. So, this is the very important definition under the Prevention of Corruption Act 1988. In this session, we are going to discuss chapter 2nd, that is the appointment of special judges. Section 3 to section 6 of the Prevention of Corruption Act 1988 deals with the same. Now, let's see section 3. Section 3 talks about the power to appoint special judges by the central government or state government by notification in the official gazette. The number can be discussed or decided according to the requirement. And these judges are appointed to try any offense punishable under this act or any conspiracy to commit or any attempt to commit or abatement of any offenses under this act. To become a special judge, there is a certain qualification laid down, which is the person is or has been a session judge or additional session judge or assistant session judge. It is all about the section 3. Let's see section number 4. Cases triable by the special judges. Here, specifically the offenses which are specified in the section number 3, subsection 1, it should be tried by the special judges only. Apart from that, any offenses under the CRPC can be tried at the same trial by the special judges. And under the section 4 itself, jurisdiction has been given. The cases can be triable for the area within which it was committed. Okay, and such trial should be concluded within the period of 2 years. If it cannot be concluded, then such reason should be recorded for the same, and after giving a reasons, extension can be provided, but it should not be more than 6 months at a time, and such extension period shall not be exceed 4 years in aggregate. So this is all about the section number 4 pointers. Let's see next one. Section 5 of the Anti-Corruption Act 1988 deals with the procedure and powers of the special judges. These are certain pointers relating to the procedure as well as powers. The about procedure, the special judges can follow the procedure which is prescribed by the CRPC for the trial of the warrant cases by the magistrate, as well as they can exercise all the powers and the functions which can be exercised by the district judges, for example, to tender the pardon, to obtain evidence, or to pass the punishments, etc. In section 6, powers to try summarily, here there is a power given to the special judges to try the summary cases, and in that matter, special judges can pass a sentence of the imprisonment for the term which should not be exceeding 1 year. And one more important thing about the section 6, that there cannot be a appeal by the convicted person if the imprisonment not exceeding 1 month and the fine not exceeding 2000 rupees laid down. But suppose it exceeds the limit, then definitely convicted person can go for appeal. So it is all about the chapter 2 about the special judges, their powers, their procedures, etc. Let's see next chapter. Chapter 3 of the Prevention of Corruption Act 1988 deals with offences and penalties. Section 7 to Section 16 deals with the same. Section 7 is very important one, which given definition about the offences relating to the public servant being bribed. Here you can see that any public servant obtains or accepts or attempts to obtain an undue advantage from any person to perform or cause performance of public duty improperly or dishonestly, even obtains or accepts or attempts to obtain an undue advantage from any person as a reward, it amounts to offense. Under the same section, punishment has been given, that is, the imprisonment for a term which shall not be less than 3 years and which may extend to 7 years, as well as fine. So, take the example, suppose the public servant is given or demanded 5,000 rupees from the common person for processing his routine ration card. It amounts to a offense under this section number. So, it is very important section number. Let's see next one. Under chapter 3, that is offences and penalties under the Prevention of Corruption Act 1988, next section number, that is a 7A, deals with the taking undue advantage to influence public servant by corrupt or illegal means or by exercise of personal influence. It amounts to offense under the section number, and punishment has been given, that is imprisonment not less than 3 years and which may extend to 7 years. Now, very important section, that is a section number 8, that deals with the offences relating to bribing of public servant. Listen carefully, under this offences, not only taking a bribe is offense, also giving bribe, it also amounts to offense. So, any person who gives or promises to give an undue advantage to induce a public servant or to reward for improper performance of public duty, it amounts to offense under section 8. Now, take the example. Suppose any person given a 10,000 rupees to a public servant for getting a license all over all bidders, then it amounts to offense under section 8. For that, the punishment, which is imprisonment for 7 years or fine or both. So there is one exceptions also where a person is compelled to do so or to give the undue advantage, then he is not liable under this offense, provided that he has to report this act or this one to the proper law enforcing authority or to the investigation agencies within 7 days of giving. So it is very important one. Then the next point is that suppose such offense under section 8 has been done by the commercial organization, then it will be punishable with a fine only. Section 9 is supplementary to Section 8, where the commercial organization, this concept has been explained under the offense relating to bribing a public servant by commercial organization. Here, or under this section, commercial organization, trade, business, these concepts has been explained. Whereas Section 10 deals with the person in charge of commercial organization to be guilty of offense, where that person is responsible, then punishment has been given under the Section 10, that which is not less than 3 years imprisonment, which may extend to 7 years. So, and the section 11 also deals with the relating to the business, that public servant obtaining undue advantage without consideration from the person concerned. It is also relating to the business, trade and the commercial organization. Now let's next penalties. Chapter 3 deals with the offenses and punishment, and section 12 to 16 deals with the penalties. Now section 12 deals with the punishment for the abatement of offense. Here abatement means encouragement. So you have to write down firstly about the abatement, meaning of it. Then punishment has been given under the section 12, that is not less than 3 years imprisonment, which may extend to 7 years, and fine or both. So next section, that is a section 13, deals with the criminal misconduct by the public servant. Here you have to explain firstly what is the meaning of criminal misconduct. Here a public servant who misappropriates dishonestly or fraudulently any property for his personal use, then the punishment has been given under this section, that is imprisonment not less than 4 years and which may extend to 10 years. Now, the section 14 deals with the punishment for habitual offender. Here, when the person is doing the same offense again, that person is called as a habitual offender, and the punishment is given for him, that is the imprisonment not less than 5 years, which may extend to 10 years, or a fine or both. Then section 15 deals with the punishment for attempt. Under this chapter or under this legislation, attempt to commit an offense also there is a punishment, that is imprisonment which is not less than 2 years and which may extend to 5 years and with a fine. Then section 16 deals with the matters to be taken into consideration for fixing a fine. So there are certain pointers relating to section 16. The court can consider the amount or the value of the property or the pecuniary resources or the property involved in such an offense. So this is about the offenses and penalties chapter, and it is very important chapter from the point of view of your examination. Now let's see next chapter. Now let's see the remaining important section numbers. First one, that is the investigation officer. the under section 17, it is clearly defined that for the sake of Delhi, first of all, the inspector of police is having the right or the power to investigate under this legislation, whereas in case of the metropolitan areas of the Bombay, Calcutta, Madras, Ahmedabad, assistant commissioner of police having the right to investigate into the matters. Now, the very important section number, that is the section 19, deals with the previous sanction is necessary for the prosecution. Now, it is very, very important. No court or any court cannot take the cognizance under this legislation without the prior permission of the government. Suppose a person is working with the central government, then the prior sanction of the central government is required. If person is working with the state government, then the previous sanction by the state government is required. And in any other matter, any competent authority who has a right to remove him also, or they have to give the previous sanction for the sake of prosecution. This is the biggest loophole of this legislation according to me. Now, the last important section, that is the appeal and revision under the section 27, that the after the decision of special judges, the appeal can be laid down before the high court. Even the revision petition can be filed to the high court. This is all about the provisions of the Anti-Corruption Act 1988. This is the last part relating to the Prevention of Corruption Act, that is the recent landmark case laws. The first case law, that is the Jagtar Singh versus State of Punjab 2023. In this matter, Supreme Court acquitted man for accepting Rs 300 bribe after 20 years. Second case law, that is the Neeraj Datta versus State 2022. In this matter, the demand and recovery both must be proved to sustain the conviction under the Act. But in this matter, conviction set aside because demand was not proved in this case. Now, the very important matter relating to the section 19, where the previous sanction of the central government or state government or competent authority is required, but Supreme Court recently held that Special Court under the Prevention of Corruption Act 1988 can proceed against an accused for offences under IPC 1860 even if sanction for the prosecution has not been granted in respect of Prevention of Corruption Act offences, which is the essential or which is the requirement under section 19. So this is the landmark case law which is strengthen the power of special judges. Here we finished with the highlights of the Prevention of Corruption Act 1988. Thank you.